Hi, thanks for using My Court Coach. I'm Jalen, and I'll be your instructor as we navigate through Form F-303. This form is a declaration regarding notice and service of a request for temporary or ex parte orders. We use this form after you have actually had a hearing not had a hearing, but are setting up a hearing for an emergency order. So this form must be part of your paperwork that you deliver to the court so that the court is aware that you did or did not serve or notify the other party of the hearing. So it's very important that this form is completed. Otherwise, the court might have you come back on a different day so that you do have this form filled out sufficiently, or they might just flat out deny your request for the emergency. So this is a very crucial form. So you've already set up the ex parte hearing and you've already contacted you may have already contacted the other party. If you haven't contacted the other party, don't intend on contacting the other party because it would do more harm, then you're ready to fill this form out. So you have to specify who you are, who's the person that's filling it out, so whether it's your attorney or somebody who's not necessarily a party to the case, but they are related to you in some fashion. Maybe they're the ones that called the other party to notify them about the emergency hearing. So now you have to tell the court, well, did you or did you not give notice? If you did give notice, then you are going to check off these two boxes. I did give notice that there will be an emergency hearing on a request for temporary ex parte orders. And if that's the case, then you're just going to fill this out, and you're going to also fill out the date and time and where the hearing will take place. Because remember, if you did give notice, you must notify the other party of the date, the time, and location, and also why you're actually proceeding with this ex parte. So if you did not give notice, then you will need to check off this second box, and then you will also check off this other box right here. The papers will be submitted because you still have to prepare and submit the paperwork to the court if you don't want the other party, even if you don't want the other party to know that you are in fact taking these steps to obtain emergency orders. So you have to get the court orders from somewhere, and that's going to be from the judge, and you'll still be preparing the paperwork to submit it to the court. And because the other party is not being provided with notice, you're okay with proceeding without a hearing, and you just want the court to proceed based off of the paperwork that's submitted to you or submitted to them. So that date and time still must be completed regardless of whether you give notice or not. So the notice section says right here, if you gave notice, complete 3A. So 3A is all the way up through section 4, or actually section 6, sorry. And so you're going to provide that you gave notice to whom, by which way did you give notice. You can, in fact, also give notice via writing, via email. And, sometimes if you actually can do this, is you can kind of take one of these line items and say that you did it by email, and write the email address and the time in which you sent the email. But it is going to depend on your local rules of court. So for San Diego County, there's not an issue with that, but maybe for other counties, there might be an issue with you doing something like that. So you really need to check your local rules of court about that. So giving notice, it has to be 10 a.m. the court day before this emergency hearing. And then if you did not provide it at 10 a.m., then you have to explain to the court why. There has to be exceptional circumstances. So exceptional circumstances can be, for example, that this incident took place at 9:45 and you didn't have time to call the other party on time, but you wanted to schedule the emergency hearing and you had to call them at 10:15 or 11:15, whatever it might be. And so if that's, the case, then you would go ahead and explain that. And the court may or may not deny your emergency request for not providing sufficient notice to the other party. So you notify the other party that the temporary emergency orders that are being requested are, and you have to specify for child custody and visitation, or you're requesting and child support orders, or you're requesting that you have exclusive possession of the residence that you two own. And then you'd have to write what the other party responded. So if they said, no, I'm not in agreement with this, then you write that they stated this, and then you also check the box that they did not, or they are in fact opposing this request for a temporary emergency order. Now, if you don't want to notify the other party, then it's because there's going to be some immediate harm of some sort. And so the court identifies danger or irreparable harm to you or your children, risk that the children will be removed from the state of California, there'll be loss or property damage if you notify the other party, or some other exceptional circumstance. And then facts and support to waive notice. So you have to explain what the danger is, or what the risk is, or what property would be damaged and in what way. And then if you're not able to provide notice, if you can't locate the other party, then you have to explain to the court how you used your best efforts to notify the other party. And as you can tell, like on the side here, it says attachment A3B, 3A5, 3B, 3C. And so those attachments, there's no specific form for this. You can create your own document and just label it attachment 3A5 and literally attach it to this form. That's all that means. Now, service of forms. Now, this is tricky because it says here that you essentially need an unfiled copy of a request for order, the FL-300 for the temporary emergency orders, the temporary emergency ex parte orders, the form FL-305, and related documents. Like, you have to serve those documents. And an ex parte application doesn't require all of those documents to be filed in or served or even prepared and submitted at the time of your ex parte application, because your ex parte application has a section for the orders, and the courts can make the orders right then and there on that ex parte application, which is more oftentimes than not, that is how the court grants ex partes. But you could take it a step further and have those two forms prepared in case the court denies your request for that day, and you can go ahead and file your paperwork on its regular calendar if the court didn't deem your emergency an actual emergency. So if you did fill out these forms, then you would complete this section, and you could even, if you didn't even fill out these forms, but you filled out some other forms that you actually were going to go ahead and give to the other party, then you can cross these sections out and just write what it is that you prepared to give to the other party in preparation for the ex parte. Now remember, anything that you want the judge to see, the other party also has a right to see as well. So there's the petitioner that you could have given these documents to, or the respondent, or the other parent, or the attorney, just anybody who you are asking relief from. You would need to provide the paperwork to. So, and anything that the court's going to see, they also have to see too. So the method of service can be personally delivering it, faxing it over, overnighting it, or even email. So again, you could cross off one of these sections and just write email and the email of the other person and the time that you emailed them. And then if documents were not served, then it has to be due to exceptional circumstances, and those exceptional circumstances are provided here. If you want the court to waive it because it would do more harm, then good to notice the other party, or you're just unable to provide that notice. And if you have more information that you wanted to go ahead and explain to the court, you can do that in an attachment 4C. Please make sure you date and you print your name and you sign it. It's very important to go ahead and ensure that these sections are completed, because it is signed under penalty of perjury. So you're basically telling the truth, the whole truth, and nothing but the truth. And the court will accept your paperwork and accept your declaration regarding notice and service sufficient, and you can then move on to the next step. We hope that you found this helpful, and thank you for your time.